Good afternoon.
Good afternoon.
May it please the court, my name is John Jones. I'm the appellant in this matter. I will be pro se today. Without a contesting party, I believe that's eligible to speak on the matter. I don't guess I'll need to reserve any time.
That's correct. Unless you want to reserve some time to rebut anything you say. No, so, you've got your 15 minutes.
All right.
Yes, sir.
All right, thank you very much. This matter before the court today is the review of the trial court's placement of age 11, age 6, with their maternal grandparents, Mike and Tammy Patton. This case is unique because while this matter was ongoing, the Tennessee State Supreme Court issued its opinion on the matter of Cox v. Lucas, where it found that all trial courts hearing matters of domestic relations should have concurrent subject matter jurisdiction to hear matters of dependency and neglect, unless filed in the juvenile court to invoke that court's exclusive original jurisdiction. Whereas up until that point, the juvenile courts had had sole jurisdiction over dependency and neglect matters exclusively. This change occurred while the grandparents' petition was ongoing, and it created the irregularity and the prejudice in the proceedings that brings us here today. It was that ruling that made it possible for the Chancery Court to misinterpret the transfer of the juvenile court to the Chancery Court as a transfer of the issues of dependency and neglect rather than just simply the subject matter jurisdiction for placement in the Chancery Court. The transfer, however, was actually the transfer, however, was actually meant to be solely a transfer of the subject matter jurisdiction over the minor children in the post-divorce proceedings of Jones v. Jones, case number 18496, so that it can continue with permanent parenting scheduling of Bentley and Sadie between the parents, myself and my ex-wife. With that, I'd like to begin with a little background of how we got here and address my first point. In December 2017, Mike and Tammy Patton filed an emergency custody petition in the Murray County Juvenile Court requesting custody of the minor children due to the mother's drug use and abandonment of the children. The emergency aspect of the petition was denied, but a court date was set in the juvenile court. At that hearing, the mother admitted to drug abuse and leaving the children with the parents for extended periods of time and explained that she was cooperating with the Department of Children's Services. I was unable to be present at that hearing to contest the matters because I was at the Davis County Drug Court receiving treatment for prescription pill abuse. Being unable to attend the hearing to properly defend myself in the allegations, the court chose to issue an ex parte temporary custody order until I could appear before the court and be heard on the matter. Now, to confuse things a little bit further, on December 28, 2018, with the dependency and neglect still pending, I filed for and received an absolute divorce from Samantha Jones on the grounds of marital misconduct. The matter of the parenting plan, that there was a proposed plan filed, but it was not dealt with because at the time, I don't believe Cox v. Lucas had happened, and the jurisdiction of the children was still resided solely in the juvenile court. So a default judgment was entered as a result of Samantha Jones not contesting the details of the petition, though she was there. The parenting plan was not addressed, and that summed up the details of the divorce at that time. So in other words, the matter, the post-divorce matter at that point was put on hold. So moving forward to November 13th, 2020, I appeared in juvenile court represented by counsel and successfully defended the allegations of dependency and neglect. Hearing was brief as Michael and Tammy Patton testified at that time that they no longer believed there to be an emergency situation and acknowledged that they had been regularly allowing the children to stay with me overnight during the week and on the weekends at my residence in Nashville. The juvenile court order from that hearing, found on page 60 through 62 of the record, stated its intentions to issue summary judgment in favor of the father. Went on to say, without issues of dependency and neglect, the sole remaining issue of temporary custody filed by the father was a placement decision and a post-divorce matter of Jones v. Jones 18496. They felt that that placement decision was better served by the Murray County Chancery Court. I, through my counsel, informed the juvenile court of my intention to file in Chancery Court a petition to seek seek a permanent parenting solution after the juvenile court matter here had been resolved. So the law in the case that I referenced in my brief in re Alasia requires that, and this is an opinion from this honorable court, requires the children to be reunited immediately from the custodians of which they were removed upon dismissal of a petition alleging misconduct. The juvenile court, rather, in this matter, in the juvenile court, chose to, rather than make a placement decision, which is how they viewed it, it would wait and to sign the dismissal on the first day of the Chancery Court hearing so that placement arguments between the parents could be heard in Chancery Court. Although the juvenile court's order may seem reasonable, I believe that the juvenile court erred at this time respectively because once the court determines that allegations of dependency and neglect are without merit, a pretrial temporary custody order such as the ex parte order in this case should have been dismissed without delay, and the defendant or parent, custodian in my case, and their children should be reunited immediately so that the child may return home and we may continue on with our lives with as little interruption as possible. The time difference was a little over a month between the November 13th hearing in juvenile court, where the summary judgment was intended to be issued, and the first day of Chancery Court, which was December 18th, 2020. It's my belief that the matter of placement did not need to be argued, as I, the petitioner, was the only person to have filed a proposed parenting plan at that time. The mother and the grandparents were served with the father's petition and with proper notice, and both simply chose not to respond or to file a proposed plan. The mother was also given instructions by the juvenile court to petition the court when she had finished her work with the Department of Children's Services, which she had not done. There's not a statement of the evidence of this testimony in the technical record, but it's my belief that proof of this testimony through the record can be found in the summary judgment, or in layman's terms, a judgment without a trial, as I described just a minute ago, when the court found no need to continue after they testified that they did not believe there to be an emergency situation. So the juvenile court waited to sign the dismissal order until the same morning of the first Chancery hearing. It still dismissed the grandparents' petition in full, ending their temporary custody order, which returned back to, in my belief, and which this is where I believe this case to be one of the biggest factors. With the dismissal of that juvenile court petition by the grandparents, where was the custody status? Because the court did not issue guidance. They simply dismissed the petition altogether. What they did transfer is the matter of placement of custody between the parents. So I believe that meant the grandparents were to be done with this matter, because without the matters of temporary, or without the matters or the issues of dependency and neglect, this is simply a post-divorce matter. I believe that, let's see, even though the juvenile court waited to sign the dismissal order until the same morning of the first Chancery hearing, it still dismissed the grandparents' petition in full, ending the temporary custody order, of which returned custody back to standard split joint custody between the parents, who at this point were legally divorced. That was the problem. That was where we were at, because in the meantime, we had gotten divorced. So to simply return the children back to the custodians as they were before presented a problem. That's a divorced couple who does not live together anymore. So moving forward to the Chancery hearing, the first day of Chancery hearing, the Chancellor referenced Cox v. Lucas and stated that his interpretation of where we were procedurally, or the posture of the case, was that the juvenile court found that the post-divorce matters ongoing needed to be, since there were post-divorce matters ongoing in the Chancery Court already, this matter was a matter better served of all the issues in the juvenile court. That was the interpretation by the Chancellor. That's what I'm contesting through this brief. And the juvenile court transferred the matter in its entirety to the Chancery Court. That's what the Chancellor believed. In fact, on page 64 of the record, the court, through it order, states that this matter is a continuation of the Murray County Juvenile Court matter 17-JV-392. It specifically says that. It also goes on to say that the court previously found that on December 18, 2020, the court did not have enough information to determine whether either or both parents were to be fit to be a residential parent, or that the parents were in a position to have joint parenting responsibility. This is the first hearing, and we're 10 minutes into it. The judge, while trying to catch up on the posture of the case, made this determination. And the Chancery Court was treating this like the children were adjudicated, dependent, and neglected by the parents, which was not the case. There was not an adjudication. There was not an order stating in writing what brought forth an adjudication.
But weren't the children adjudicated, dependent, and neglected in the care of the mother?
No.
No. Okay.
No, because we did not have time. We did not have a trial at that time.
In the juvenile court. Okay.
Correct. That hearing. The only hearing that took place was the hearing that happened after an emergency. The emergency aspect was denied, so then a hearing was scheduled. Okay. So at that point,
and that hearing was not an adjudicatory.
No,
hearing.
It was not.
Okay.
And in fact, the mother just simply agreed to the temporary parenting plan, while she handled her issues. And of course, I was not there. Now, what I do believe caused the judge to have confusion to the matter is that I believe he saw us to be one, when in fact we're actually divorced, because we are both defendants in the matter. Now, one thing I would like to, why I believe, let's see. With the issue, why I believe that the relief that I'm requesting is appropriate. That's something that I do believe should be addressed. I do believe that it's clear that with the judge's statement, which I just told you, the prejudice towards this hearing is not in question. This was simply a proposed parenting plan. We've already resolved the matter. These are allegations that were not founded in juvenile court. They were not proven. They were dismissed. And without the issues of dependency and neglect, the juvenile court said, okay, this is a placement decision. Okay, so we're going to transfer this to the Chancery Court, because this is not my call to make, which is completely understandable. In fact, my attorney who filed the petition in Chancery Court, if you look at it, will show that I'm the plaintiff. Samantha Jones is the defendant, and the grandparents aren't even on the petition. So that just further goes to explain that.
Did the grandparents participate in any way in the Chancery Court?
They did not file any parenting plan. They simply showed up, and then the judge asked them questions. The judge brought them involved. They did not file a proposed temporary plan. They did not file a proposed parenting plan.
So in the order of June 4th, 2021, where the Chancery Court says the court affirmatively finds the permanent parenting plan that has previously been submitted to be incorporated herein by reference is in the best interests of the minor children, what parenting plan is that?
That is a parenting plan that they created.
They
is in the court on its sua sponte. I mean, it's because the grandparents did not file a proposed temporary plan or permanent parenting plan. In fact, the only person who actually filed a parenting plan was myself. Now, during the course of these proceedings,
so the trial court, the Chancery Court essentially found, and please correct me if I'm wrong, I'm trying to understand.
I understand. Yeah.
The trial court essentially found that neither you nor the mother should have custody of these children, and it looked around and there were the grandparents who had had them before, and it pulled them in.
This is a big factor. What you're asking is, as I understand it, here is a very big factor. The court, throughout the entire proceedings, that was what led to the court thinking that I was, but in fact, they found me uncredible because I was continuously saying, Your Honor, this is not the case. The grandparents, you're taking the children away from me, and the court disagreed. They're saying we're not taking the children away from you. We're leaving them where they're at. They considered this temporary parenting plan to still be in place, so they were the solution. Now,
the plan that was put in place in juvenile court.
Right, a temporary parenting plan.
And your position was that had been dismissed, and so that's done.
Right, exactly. And that temporary parenting plan had expired with the dismissal, which was the point. That was the entire reason that the juvenile court waited until the date of the first chancery hearing to dismiss it, because the juvenile court was also with the understanding that, hey, when we dismiss this matter, the children are going to be left without a parenting plan, with two parents who are now lawfully divorced.
And there's no transcript of anything in the Chancery Court. Is that right?
Well, I tried to file that, and I actually have a video on my phone, which I have here today, of the entire hearing, which you can hear the entire hearing.
But
Did the court? I'm sorry, Judge.
the record has no.
The record, unfortunately, no. The judge denied that. The biggest factor is, to specifically answer what you just asked, the court found not that I was, or that the mother was unfit to be custodians of the children, but that they did not have enough evidence to say that we were. And that is the entire basis of this appeal, is because the children had not been adjudicated dependent and neglected. In fact, I was issued a summary judgment in this matter, but because the grandparents, the petitioners, had stated that there was not an emergency situation at that point. So the judge, it was my position, which I stated continuously throughout the trial court proceedings, that if for the court to have any concerns of this, those concerns should have happened between the time that they signed the dismissal and the beginning of the Chancery Court hearing. So in other words, a window of about 2 hours, because these issues have been dealt with in full. And so that was in other words, the court specifically was putting the burden of proof onto me to prove my fitness as a parent, when in fact the law has a presumption of fitness already, and that they were in turn asking me to prove all of this. And they're saying, well, we don't have enough evidence, when in fact, actually, if in order to not give me the benefit of the doubt, there should have been evidence provided by the grandparents as to why I'm not fit. And the grandparents were not presenting any evidence whatsoever. The record will clearly shows that there's only evidence supporting why we are fit, not as to why we're not.
Hey, make sure that I understand this too. The permanent parenting plan that the trial court attached to its July 19 order, who prepared that permanent parenting plan?
The guardian ad litem.
The guardian ad litem, and okay, not the grandparents.
Nope. The grandparents did not file a proposed parenting plan.
When did the guardian ad litem prepare it? Was it before the hearing?
No, it was actually after the hearing. I never saw the hearing until it was signed and in order. That's why it was, the hearing happened on June 4th, and then the order was signed on July 19th there. And so that was one of the big factors was that the trial court used the juvenile court's temporary parenting plan. They ruled it as first they ruled it as a continuation of the juvenile court matter, which then led to the trial court seeing the grandparents as parties of interest because they had temporary custody of the children. At that point, now that they have the grandparents formally issued or viewed as parties of interest, now they considered the grandparents along with myself and the mother under the arguments of 36-6 forgive me, they considered all three of us. And so the guardian ad litem, along with the court, ruled that the grandparents were the better fit. But the grandparents did not actually have a place in this matter because they didn't file for it. They didn't request it. In fact, the judge ordered, I believe, from a hearing on January 20th or the 22nd, the judge actually orders everyone to file an updated parenting plan. Even though the mother didn't do it, even though the grandparents didn't do it, which was upsetting because I believe that I'm the only one that's handled this properly. I'm within the guidelines, but he ordered everyone to. The grandparents still didn't do it, which leads. It's very reasonable to believe at that point they weren't looking to be custodians of the children. They never filed a parenting plan at any point in time, and then the court says there's not enough here to say you are fit to be a parent.
Well, what does the court do when the court finds that it would be detrimental to the best interests and welfare of the minor children were they allowed to return to the primary residential care of either mother or father? Sorry, I don't mean to insult you. That's reading what it said.
That has been absolute. Let me let you finish.
So the court, I guess, was looking for something to do with these children and grabbed onto the grandparents. Is that the way it worked?
That's certainly what. Yes,
okay.
Yes. Now I do say I would also argue that with the judge described this matter as a procedural nightmare. That is what he described it as. And even with this parenting plan, there was also, I argued, I said, well, shouldn't we now immediately initiate dependency and neglect hearings? Because the one thing that should be considered, in my opinion, is that if there are concerns of dependency and neglect, you have to first rule out the parents before we can get to the grandparents. They do not have superior parental rights over the children, and they're not seeking them. They're not seeking the custody of these children. So the confusion is what continued to hold the judge up consistently was that, in my opinion, here we are with allegations of drug use. But that's the grandparents' allegations that began in the juvenile court. Here we are now. He's concerned. He doesn't know. He doesn't believe that the matter was fully dealt with in juvenile court. His words were specifically, quote, "Well, Mr. Jones, I don't know. Was this matter actually dismissed on any merit, or was it simply transferred to the Chancery Court because the law has changed, stating that trial courts that hear matters of domestic relations are now, have jurisdiction over dependency and neglect matters. So his concern was that are we supposed to rule out dependency and neglect first and then deal with the placement? And he was concerned that was being slid under the rug, when in fact that was not being slid under the rug. The grandparents did not submit anything in the form of evidence. They simply just they filed a petition. We came to court. Through my attorney, we had that hearing. They dismissed the matter. In fact, they didn't just dismiss it. They issued a summary judgment, a summary dismissal, which is not just that should have answered the judge's question. Is this dismissed on any merit? Yes, it was a summary dismissal because there is no need for a trial, because these allegations cannot be supported in any form or fashion.
Was there, and I know we're going, okay, there's no transcript. So we don't know, I mean, did you have a hearing for your divorce? I mean, was there?
Yes.
You testified, your wife testified?
Yes.
And there's no transcript there, there's nothing?
In front of the same judge, actually. This was in front of the same judge in the same court. We actually, the divorce, when we were there, I had my complaint. She did not file a response. When we came to court, she was there. The judge asked her,
I'm sorry, go ahead and finish your answer.
That was it. Just
Okay.
simply that, do you contest any of these, the allegations in this complaint? She said no. And he said, okay, I'm going to grant you your divorce. I'm going to find a default judgment.
That was before this hearing.
That was before all of this. That was in the midst. That was in between the time that the grandparents filed in juvenile court and the time that I appeared before the juvenile court to have this matter dismissed. What's so confusing here is the length of time, because I was in that treatment program for over a year.
But there's no I'm sorry I'm beating on this.
No
but
problem.
There's no transcript that says what you just said happened. Of the
Correct.
hearing?
The June,
Which
talk
the-
about the June hearing, the most recent hearing where afterwards Judge Parks issued his opinion where
Judge Sockwell.
yeah, I'm sorry, yes, did the parenting plan with 54, and mostly with the grandparents.
What about it? I'm sorry.
So at that hearing, the hearing after which the court entered the guardian ad litem's drawn up plan.
Right.
At that hearing, the court swore in witnesses and heard testimony.
The court did that from December 18th was the first day of this hearing, of this trial. December 18th was. The June 4th hearing was the last day of it, in which they issued that the grandparents would stay, or that the children would stay with the grandparents. Now it says it through, what you're asking is there a statement of the evidence? No, there is not, but you can follow it through the orders on the record.
So,
That is,
well, the question I'm trying to pinpoint though as at either this December hearing or the subsequent June hearing, were there any witnesses sworn in and testimony taken?
yes.
Okay.
Yes, there was. Now, what part of what I'm appealing here, and the one of the biggest factors here, is that the prejudice of this hearing was not, there was irregularity, extreme irregularity, because the court is viewing this as a dependency and neglect matter. It says it on page 64. This is a continuation of the juvenile court matter, JV 17-JV-392. Though it can't be a continuation of the juvenile court matter, because the juvenile court matter has been dismissed, which he references.
And the court never found dependency and neglect.
No, sir, they did not.
Said it was a continuation of the juvenile court matter, but then never made any finding one way or another as to dependency and neglect.
The juvenile court, no, actually they did. They issued this, what they believe to be a summary judgment. It says it in the order that the judge references in the record. It says that this matter, from testimony, it says through testimony, given the evidence, and in consideration with the court's time, the court hereby issues summary judgment in favor of the defendant.
That was the juvenile court.
That was the juvenile
But the Chancery Court never made a DNN, a dependency neglect finding in any way.
Right. Well, no, they didn't. In fact, that in order, and that's part of it. That not only this matter should have only been a post-divorce hearing, just like any other one. Now that we've got this resolved, because just like even though they gave the Cox v. Lucas gives other courts jurisdiction to hear the matter of dependency and neglect, that does not change the procedural aspect in which, if we have allegations of dependency and neglect, everything else stops.
Yeah, you thought you were just going to court to enter into a permanent, have the court enter a permanent parenting.
Right. We're done with it. We're done with this matter. Now we're here, simply here, to have a permanent parenting plan. And I actually filed a temporary one first because there was a necessity to have one that day. The juvenile court recognized that the children were going to be coming home to eat to one of the parents, because that's why they waited until the first day of Chancery Court to sign the order. We didn't have any more hearings after that. You see what I mean? They waited a little over a month to sign the order, because when we signed the order, the grandparents are done at this point. Their custody order is done. The dependency and neglect matter is done. And so now we will have the Chancery Court, before anybody leaves, will have the opportunity to hear arguments over placement. Does that make sense? That is clear evidence as to the juvenile court's position on the matter. This matter is done. But it's also clear that the Chancery Court did not see it that way. There was just, it's just a misunderstanding as to the proceedings of what they were. But unfortunately for my case, it was detrimental, because I'm not there to prove that I'm fit to be a parent. I'm there to prove that I am the better fit in comparison to the mother only, not just to prove that I'm already with my attorney who at that time, like he said, okay, we've got this resolved. Now it's just, we need to show the court why you're the better solution for a primary parent in comparison to the mother. And the judge is saying, this is you're not, we don't have enough information to prove that you're fit. But why would I need to prove that I'm fit if nobody's ever proven that I'm not? There's no difference in that than anybody else that comes into court.
All right, again, I think I know the answer, because you told me, but again, Chancery Court, and you also, Judge Bennett, I'll make sure I'm right about this. The Chancery Court made no determination as to dependency and neglect.
No, sir. Had they done so, we would have had to, there would have been an adjudicatory hearing. And at that hearing, they would have issued in writing their reasons as to why the children have been dependent and neglected. And as the record shows, that did not happen. Everything before us was simply concerns, what if matters. And I just don't believe, in the absence of having that hearing, that adjudicatory hearing, and the dispositional hearing, that you can place a permanent parenting plan to grandparents who did not request it. This is essentially an emergency aspect order. I believe I'll take that as you understand. I don't believe I need to say anything further. Yeah,
you've done an excellent job today. Explained it to us very well. We appreciate your answering our questions. And I at least have have a better understanding of
It's-
where we were
It is
before
very
we started
difficult. It
this.
is, like I said, the trial court, I knew this was gonna be tough. The trial court said that this is a procedural nightmare. But I do believe that, you know, you can always point your finger at what if. I do believe the biggest factor was that had the juvenile court done what this court has already found through the case I referenced in Realasia, whereas immediately the court should return custody to from whom which it was taken immediately upon the findings that upon the dismissal of the allegations of dependency and neglect. There was not need for arguments to be heard because this is simply, here's my proposed parenting plan, she did not file one, the end.
All right,
and that would have stopped everything in Chester.
We understand. Thank you very much, Mr.
Have a good
Jones.
day.
Recess court until tomorrow, please.
All right.